It's a completely virtual meeting, and yeah, I don't have to explain too much about the reasons why we went completely virtual. But nice thing is that you can, in those days of where pretty much everything's uncertain, you can still rely that the CodeX group meeting will happen on Thursdays at 1:30. So we have an exciting meeting ahead of us today. We have three wonderful speakers with us today. We have Sonia Ebron. She's the co-founder and CEO of Courtroom 5. And then we have Sean Miller, who's our very own CodeX affiliated faculty, who will be speaking about the Stanford NPE litigation database. And then we have our old friend Gabe Suckman, CEO and founder of Clearstone IP, who will be joining us too. So we have we have three presentations today. We'll try to stick to our hour, so that gives everyone about 20 minutes to present. But before I turn it over to Sonia, I wanted to see if anyone has any kind of updates or news to share for the group. If so, please unmute yourself so we can hear you. You can also use the chat function in Zoom. All right, doesn't sound like there's any other updates. In that case, let me turn it over to Sonia. And so, hey, Sonia, good to see you. Where are you joining us from?
Durham, North Carolina.
Great, great. Well, it's great to have you. And yeah, we're excited to hear about what you've been up to with Courtroom 5.
Thank you.
Please take it away.
Happy to join you again. I visited you all briefly. I think it was back in November with the LexisNexis Tech Accelerator. So
that's right.
Good. Fantastic.
Yeah.
So I'm gonna share my screen. I've got just a few slides to share with you to set the context, and then let's see. And then I'm going to take you under the hood to demo our product just in a few minutes here. So just for background, I don't have to tell you all there's an access to justice crisis in the United States. There are millions of us, millions of Americans at risk of losing their homes, future wages, access to their kids simply because they don't have a lawyer. And so my co-founder and I, Deborah Sloan, unfortunately, we are intimately familiar with the problem. Neither of us are lawyers. And we've been in court without a lawyer and been denied justice as a result. Now, we are both PhDs, former academics, so we're not your typical pro se litigant. We have, over time, learned sort of the landscape of a civil case. And as former academics, we felt that we could share what we'd learned with the millions of other people who needed to understand how to move through a civil case. And so we developed a case management platform for people in civil court without a lawyer. Currently, we offer it on a monthly subscription basis for about $25. But for further background, there are, by some estimates, 20 million pro se litigants in US civil courts. And that's outside of traffic court or small claims court. There's a pro se litigant present in about 3 of every 4 civil cases in this country. What's surprising to many is that in 90% of those cases, there's a lawyer on the other side. In fact, most of these people are defendants who've been dragged into court by a plaintiff's lawyer. And that's really not a fair fight. And as a result, most pro se litigants are denied a fair right to be heard in court. Now, we've won some awards. I mentioned the LexisNexis Accelerator. We also graduated from the Duke Law Tech Lab and some other programs there. But just briefly, how does this work? Let's say this is our member, we'll call her Mercedes. She's just been served a debt collection complaint. There's a credit card company that had charged her fraudulently a membership fee. And so she stopped paying on the credit card. Now, while the bank has a lawyer, Mercedes here can't afford one. So she comes to Courtroom 5, and the first step is to upload that complaint. that triggers our navigator. We call her Sylvia, but she's an artificial intelligence agent that helps Mercedes decide what she wants to do next about this. Now, why is that necessary? Well, Mercedes is not in Judge Judy's court, where you simply go and tell the judge what happened and expect the judge to make the right decision. A study, I think it's maybe 10 years old or so, from Chicago Kent College of Law showed that your typical litigant has nearly 200 discrete decisions to make and steps to perform to get to a rightful outcome in the case. And so, as our member Mercedes proceeds through her case, our navigator, our artificial intelligence agent, tracks her progress and spoon feeds just the right legal information and pointers to appropriate tools on our platform, like document templates for common legal filings, legal authorities like statutes, rules of procedure, searchable case law, everything Mercedes needs to make her best case in court. And in that way, we help each of our members reach what we think is a better outcome than they could achieve on their own. So with that background, let's take a look under the hood very quickly here. This is our tool set. This is a basic console for our product, and you'll see a number of tools here. There's a filings tool for maintaining a record of your case, so you don't have to visit the clerk's office. There's a documents library for templates for filing all of the things you might need to file in your case. There's a laws tool that has links to statutes and rules of procedure, but also searchable case law. There's a task tool to make sure you're on track with whatever you need to do in your case. There's an evidence manager, an expenses manager. There's a counts tool, I'll show you that in just a moment, that helps you analyze your case at various stages of the case. There's a damages calculator and a basic notepad. Down below on the main console, there's just a quick links to the most recent things you may have stored in each of those categories. So your latest documents, the latest legal authorities you may have found helpful, the latest task you've stored, and so forth. So you always can get back to the most recent work that you're doing. Before I take you further under the hood, it's important to understand that most of the people who come to us don't understand the litigation process. And so we make sure that people have just a basic understanding of what they're going to face. So there are a number of courses, each of them with several lessons. We walk people through the various stages of civil litigation. We show them in introductory legal skills, how to write a motion, what side of the courtroom to sit on when they go to court. There's introduction to basic civil procedure and some other things. There's a more fulsome course on civil procedure. Again, just the skeleton, but we show them how to find the rules that might apply to the various steps or procedures that they're engaged in. There's a course here on finding legal authorities. Let me just show you as an example of what one of those lessons might look like. So here's the course outline. There are just 5 lessons in this particular course. All throughout, if users like, they can take notes based on what they learn in these courses. Let's take a look at one of the lessons, the case law or appellate opinions lesson. Each of these lessons has a few minutes of video instruction, but also an outline of just what will be should be understood in that lesson. Some of the lessons and courses come with handbooks that are referred to in those lessons. So just briefly browse through this particular handbook. But let me go back and just give you maybe a minute or so of a sample lesson here. Hopefully you can hear this.
Hi, I'm Matt, and this is lesson 3, appellate opinions, case law. In this lesson, the phrases case law and appellate opinions are used interchangeably.
Actually, I can't hear it. I don't know about others, but.
We'll start with an introduction to case law. Then we'll discuss finding case law.
Yeah, unfortunately we didn't test the audio, Sonia, so I don't think your microphone is strong enough to pick that up.
Yep, no worries. Let's go on back then to the tool set. And I think I'll start you with the counts tool. Let's take a look at that. Just a moment to move some things around here. There we go. Yeah, and so this is just a sample, though, of some of the instruction that we have available for people. We emphasize to our members that they don't really understand litigation the way they've seen it on TV, and so we make sure that they have some access to the basic instruction on the litigation process. The counts tool is sort of it's a case analysis tool that helps people understand the claims against them if they're defendants or if they're preparing a complaint. They may want to just outline their claims as a count. And the counts tool essentially walks people through the elements of, again, their claim or affirmative defense and connects it to any of the factual allegations and the evidence that they can collect or need to collect. And so that they're always aware, they're asked to just outline what the elements are of their claims, go through the pleadings and understand what facts are being alleged, and then any evidence that they may collect or have already collected that would support each of those facts. And it's a quick way for people to understand. And again, they have to provide all of this information themselves. It's just a tool for helping them do that. But it helps all of our members understand that, first of all, there are elements to everything that's pled. It helps them, if they're a plaintiff, make sure that they have a complaint that's sufficient, or if they want to fight off a motion to dismiss it. If they're a defendant, likewise, they can analyze the claims against them, prepare a motion to dismiss if they see any elements that are insufficiently supported by fact in the complaint. It's a tool that you can use throughout the process, though. So if you're preparing discovery, you may want to outline, again, the claims and defenses to find out what evidence you need to collect, or what the impact of turning over certain evidence would have on your own case when you're preparing for trial or dealing with summary judgment. Again, it's a quick way to just see what your status is so that you can adequately prepare for those sorts of procedures. And so that's sort of something that we ask people to use frequently throughout their cases. Let's take a look at the laws tool. As I mentioned, we encourage people to find supporting authority for anything they're arguing in court. Our member Mercedes here, and before I do that, let me just show you on the sidebar. There's quick access to all of the tools on the sidebar. When a member first joins our platform, they are asked to provide information on the parties. So you'll see Mercedes has entered information on herself and on the bank that's suing her. There's information on the court that might include the judge's name, the name of the court, the name of and contact information for a judicial assistant, and some other things. And on the sidebar on each page, there is, and I won't show you a whole lot of this, this is confidential, but our members have an online community where they can share information amongst themselves. So at any rate, all of the information on the case and on the parties is included in everything our users do. But Mercedes here is in Ohio. And so we can go and search on Ohio case law here for her. Let's say she just wants to search on the Supreme Court there in the Court of Appeals. If she wants to search on, let's see, membership fee, fraudulent, just making something up here. Then she can search on those, and there are beneath the search field there ways to narrow her search as well. But this particular search provides Mercedes with about 65 opinions, again, and just in those two courts, the Supreme Court and the Appellate Court in Ohio. And, you know, she can go and review those opinions. She can save and store that opinion if she finds it helpful, along with any notes about how she intends to use that case law. And so she has access to all of the nation's case law here. But in addition, as I mentioned, she can also search on Ohio statutes if she likes. There's just a link there. She can review the rules of procedure, the rules of appellate procedure, any kind of administrative rules for the state of Ohio, anything that's available for her to review as she needs to in her case. And again, anything that she finds helpful, she's able to store that immediately, and so that she doesn't have to repeat any search for any of the legal authorities there. Let me briefly show you our documents tool. I think this is just very quickly, let's say Mercedes had earlier prepared a motion for extension of time. Now again, the caption is going to be the same for any document she creates, but she would be able to go through and just create a quick motion for extension of time. Her signature is already prepared for her, the certificate of service, information on the party that she's serving is already prepared for her. And so all she has to do is view a PDF of that document. Hopefully you can see this as well. And it, she has available to her a professionally formatted document, what she's prepared, along with the certificate of service. She can download that, she can sign it and file it in her court. There are, though, several dozen common documents. Let's see if I can show you a few of those. Just
I
to
just wanted to ask you to also leave a little bit of time for questions, because
we're
20 minutes per presenter.
Yep.
Presentation and questions. So if you wanted to show something else that you definitely wanted us to see, please go ahead. But you might just want to open up for questions too.
Yep. I've got about 90 seconds here. I just want to get you to the best part. So this is our document library. There are various motions, notices, the discovery templates, various pleadings, and some other things that our users might find helpful. I obviously won't take you through those, but I did also want to show you, if I can, very quickly, just how our navigator works. And so if you were to, for instance, upload a complaint there, let's say that had been filed by by the bank, very quickly here. Let me see if I can just upload the complaint there that had been filed in the court against you. You'd want to indicate that that is a pleading. The various pleadings are available for you there. And there's some other comments you can make on that upload. And when you save that, our navigator will hopefully show you something that she has to say once that is uploaded. But you'll have there a copy of whatever has been filed in your case. This is just a sample. And you'll see the navigator pops up here with a quick tip for some resources that are helpful to you at that point. I'll stop there. There's obviously lots more under the hood here, but I just wanted to give you a basic overview of Courtroom 5's case manager. Happy to take any questions that you have.
Thank you so much, Sonia. This is very cool. Folks, does anyone have any questions? If so, please speak up. All right, it seems like Lance posted something in the chat where he's asking, in terms of the use of AI, it appears that you're using a chatbot with some form of NLP. Can you indicate what AI tools or software you're using and in what other ways you're leveraging AI?
That is the best question. Thank you so much for that, Lance. Unfortunately, the artificial intelligence is protected by a trade secret. I can't say a whole lot about it. I'm happy to show you under the hood how it works. And if you're interested, give you free access to it so you can take a look at it. But I can't actually tell you how we do it.
Okay, cool. Any other questions? So I'm wondering, what's your distribution strategy? How do you get people to use this? Do you work with some intermediaries, legal aid groups, or you just, online marketing, or how do you get this into people's hands?
We've got a number of distribution channels on the roadmap, but currently we reach them through SEO search engine optimization. So we've got 200 or 300 helpful blog posts available. We get most of our traffic organically, which means we essentially don't pay for it. We've also done, though, some Google advertising, some Facebook ads, but not a lot of it. Most of our traffic is organic.
Okay. Okay, there's one more question. I don't know, is that also from Lance?
No, this is another question. Someone who has microphone challenges asking, what is the expected college level for a user on the website, high school or college?
Most of our users, according to our surveys, have some college, not necessarily an advanced degree or even a completed college degree, but associate's degree and that sort of thing. But there is, unfortunately, a wide range. So we do have people using the service with high school diplomas, and we've got some PhDs, but the average is just an associate's degree.
What are sort of the main motivations for people? I mean, it's probably the same motivations for being a pro se litigant, is to, like, just avoid the expense of working with a lawyer. Or what is sort of the feedback you're hearing from your customers at this point on why they choose the service and why it works for them, and where they would like the service to go in the future?
Sure. I mean, this is a heavy load for people to do. Most of our customers would certainly hire a lawyer if they could find one and hold them accountable. These are important issues that people are facing. And so, they're using us as a last resort, frankly. I think we have a long way to go in terms of optimizing the user experience, but people are willing to put up with it because they don't have an alternative. They have to go it alone in most cases.
And what's your kind of long-term vision for the service? Well, where do you want to take this to?
We want to make sure, our primary goal is to make sure that people have the opportunity to be heard in court. But, we believe there's an opportunity to realize the promise of unbundled services. The reason that it doesn't work right now is because people don't know how to task a lawyer. They don't know how to specify unbundled services that would be helpful in their cases. As you may know, the reason for the retainer is that lawyers have to do a lot of upfront work in order to serve a client. And so that's not available to them. The billable hour is not available to them with unbundled services. And so we think by educating consumers, by providing them with the tools to do their own work, that they are also more likely to be able to specify unbundled services and to hire lawyers whenever they need.
Okay. All right. Final questions before we have to turn over to our next speaker. Scott's asking if you're focused on certain states in the U.S. more than others, or are you building a roadmap for unique legal situations in all 50 states, or primarily North Carolina?
We have served customers in every state, and Puerto Rico and Guam, in fact. So we focus on helping people find the law that is appropriate for their circumstances and putting that law to use. So we've already served everyone in the United States, every state in the United States.
Cool. All right. Well, thank you so much, Sonia, for your presentation. This is very cool, and wish you best of luck.
Can you drop your email into the chat, Sonia?
Absolutely, I'll do that. And look forward to hearing from you. If anyone likes, also connect with me on LinkedIn. Happy to be in touch. Thank you so much, everyone.
Thank you, Sonia. All right.
Thank you, Sonia. Very cool product.
Thank you.
All right. So next up is Sean, who's going to give us an update on NPE litigation.
Thanks, Roland. Can you hear me?
You can hear you well. Yes. How are you doing?
You can hear me. I can hear you. Everything's going pretty well down here. Probably the same issues at the University of San Diego as you're dealing with at Stanford. So thanks for having me, both you and Susan. My name's Sean Miller, and I am in my first year as a professor down at the University of San Diego School of Law. For 6 years before that, I was a fellow, a research fellow, some years a teaching fellow, other years working with Mark Lemley at Stanford Law School. And one of the first projects that we started together about 6.5 years ago was this NP litigation, originally data set that's now become a database. And so I want to tell you a little bit about that, the motivation for it. Can everyone see my slides?
Yeah,
Okay.
you can see it.
Excellent. Perfect. So, so like I said, this is a project that started 6.5 years ago, looking back more around 2013, right after the American Invents Act, and there was still a whole lot of concern about patent trolls. And the conventional wisdom, of course, that trolls were ruining the patent system, overloading dockets for judges and patent-heavy district courts. But at the time, there did not seem to be a lot of publicly available data on exactly how many lawsuits involve so-called trolls or actually any other sorts of types of patent plaintiffs. So that was our initial motivation for creating what the aim is here, and what this project is to create a publicly available free site where we have some objective categorizations of the patent asserters, the plaintiffs, and every patent lawsuit filed in the United States from the early 2000s through the present. And so the one motivation was patent trolls, and thinking of having a resource that would be available for academics, for policymakers, and also for people in industry who are concerned about what's the litigation load coming from various types of plaintiffs. And another motivation, the second motivation, is essentially is again, so it's beyond patent trolls, just any type of empirical research, any sort of predictive study you want to do on litigation. It's going to who the patent owners are, the type of patent owner, is going to matter a lot, because you can imagine if you have startups that might have completely different motivations for filing lawsuits than some entrenched incumbent entities in different industries, versus licensing firms, versus human being inventors, versus universities. And again, before we worked on this project, there's a couple, and so RPX, of course, has really good coding of and basic breakdown of whether you're a practicing entity, someone that makes and sells products and services, or whether you're a non-practicing entity, but it's not publicly available. And there's a couple other proprietary sources of this data. We initially started working on this project for the first 3.5 years. We worked with Lex Machina, who gave us a lot of back-end support in gathering the data. And the goal here, again, this whole thing, and I'll show you later, we now have our own website where we host the database where and I'll show you what's on that. But the whole goal is to create this public resource for people able to figure out who's suing who in the patent space. And we think this has value, has a whole lot of value for scholars, but also for policymakers, and then also for people that are interested in doing intelligence on litigation in their own industries. So for the last 6.5 years, I've been working with law students at Stanford who I've had basically reviewing the dockets, the complaints, doing Google searches for different business records, for essentially to categorize different patent owners, and basically every patent owner and every lawsuit going back as far as we could. And to date, we've categorized all the plaintiffs in every lawsuit filed from 2003 through 2018. We're mostly done with the first 3 years of the 2000s. The issue there, of course, is that's sort of when it's an actual data issue, the existence of the data, because at those first 3 years, not all federal district courts had completely gone over to electronic record keeping. So that's a bit of a challenge where we're trying to fill in the gaps there. And then we've started to fill up 2019 as well, and also going to start collecting the lawsuits for 2020. And really the goal is to finish up 2019 as soon as possible and then get current and stay there. To tell you a little bit about what actually is in the data in the database. So each sort of the main attribute is one patent lawsuit. And so for each patent lawsuit, we identify who the plaintiffs are, the ones that are asserting patents, and then we assign them one of these 13 categories. And this is a little bit cumbersome, but we have a nice little paper that makes it a little easier to digest. One of the categories, and only one, is a practicing entity. That's our category 8 entity. Other ones that commonly appear in the lawsuits would be the individual, the category 9, where we have human beings that are typically the inventors of the patented technology. We have we have 2 categories that we tend to think of as patent assertion entity or troll entities. Our category 1 and category 5, and each of those is basically the difference is they're both licensing firms that don't do anything other than enforce patent rights, but one, the firm is owned by the inventors on the patents, and the other it's not. And then the other ones, really, those are the 4 biggest categories. And then you do see a lot of university litigation as well. And we have a couple startup categories, which are interesting because you don't actually see a lot of pre-product startup patent litigation. And so we're able to, this is one basic but sort of important finding that we figured out early on in this project was looking at combining what we think of as our troll type categories and comparing those with our practicing entities. That the total volume of litigation in the United States is sort of back in the early 2000s. It was much more heavily aimed towards practicing entities, but then over the course of the 2000s, we came to where we're at now. We're essentially close to 50-50 patent assertion entity versus practicing entity litigation. So I said before, when we started this project, we basically were just, we had a spreadsheet. Each row had a lawsuit on it, and then we would have a column, very cumbersome. So column 1, plaintiff for the name and the category for the first plaintiff, second plaintiff, and we realized we really needed to create a relational database with this. And about 2.5-3 years ago, we started working with Irina Zaks and Alex Shore, Irina had worked with Stanford's IT in the past, and she helped us create this neat database to capture all of our data, also to help our research assistants do the work for managers like myself and senior students to be able to check junior students' work, and then also to create on the front end this public website where users are able to search through the data and also to generate downloadable reports. And so the home for this is npe.law.stanford.edu. And I really hope all of you will go there, register, and I'll be sure to activate your accounts as soon as possible by the end of the day for anyone that registers. And there we have various searches that are available, but then also the ability to download essentially all the data that's on there. And so once again, this is a public interest resource primarily. So what's our impact been with this? Basically, one glorified data set, but doing something we think is very important. Is doing something no one else had really done, or at least made publicly available, of categorizing patent owners. Well, we have at the website, we have over 300 registered users. And interesting to me, because again, it's been similar to the last speaker, our traffic it's been pretty much organic. We had an initial advertising out to more to the academic community, intellectual property academic community. But half of our users are in consulting, startup companies that are interested in, grabbing interesting data like this and using them in their own litigation analytics tools. But then we also have lots of graduate students working on their dissertations, lots of my colleagues that I meet at different patent conferences during the year. We've already had one goal is really because I think this, and my background, I'm both a patent lawyer and an economist, and just really doing these type of multivariate studies where you need a resource like this. I really want this to be the resource in the patent space when people are analyzing litigation data. They use our categorizations of the plaintiffs. And so far we've had over 20 academic papers that cite the data. And then we've also had an impact on policy. I was able to bring a group of 8 students to DC back in 2016 and to present some initial findings, and also this project, the Patent Office. And then just a year and a half ago, actually we're able to bring 2 of my best students. The 3 of us were able to participate in the hearings, Federal Trade Commission hearings on innovation and IP policy. And we've also, and sort of one thing that, so we have the database, and then the idea is let's have people use it and really try to push that. So we've used resources for a couple symposium. We had a big one back in May 2017 with all these speakers, and also trying to have this have an impact in policy, and not just for egghead economists and academics like myself. So we had a legislative panel with congressional staffers with the hope that they would look and see what research is actually going on, and then give us a sense of Congress's appetite for different types of patent reform. And then also had an administrative panel with different agency representatives. And we just had a very successful second symposium last November as well. And our next steps, we're at a point where basically for the last 3 or 4 years, until about 6 months ago, we've had very solid financial support from not-for-profit foundation that basically that is no longer available. So I have to hit the road and try to raise some funds to basically keep this thing going. And my goal really is for myself and my students to be able to stay current, continue to add the new cases. So one thing, if you look at a lot of sort of these free data sets, often the effort stops. So you have the people that are initially involved, like myself, that have short-term goals of using this data in a couple papers, and then once it's done, it's sort of we're all end up wishing that, why didn't someone keep this thing current, because it sure was valuable, but now it's 10 years old and nothing's been added to it. I'd actually like to increase what we do within the database and start to categorize defendants, and at least maybe include some industry identifiers, so that defendants that we know of that are in some other data sets, whether they're proprietary or public, so you can match them up with the financials of companies. Also have some categorizations like, okay, this is a publicly traded company, this is a closed corporation. And then we have an issue too, using data like this, where when you really, a lot of studies, you don't want to double count, and you have double counting issues in some instances where you're considering subsidiaries as arm's length different entities as their parents. So that's something that would take quite a bit of time, but something I'd like to work on. So that's all I have for now, and I'm happy. I'll actually, while I'm taking your question, I'm going to exit out of here and bring up my website real quick. Any questions?
Thank you, Sean. This is very cool. So, what I was going to ask you, so is your main audience academics who want to understand how these non-practicing entities are impacting the patent system, things like that? Or are there sort of commercial entities interested too, policymakers? Who are your main users?
So users, surprisingly or not, when I talk about this website, and Roland, can you see the website now?
Yeah.
Okay, yeah. So users, surprisingly, like I said, it's about 50-50. And so we have, among the 50 that are not either professors or students, we have, you know, so I would say maybe like out of that, the 50% that's not academic, maybe 20% of it are firms, are bigger companies, 40% are law firms, and 40% are more startups, litigation analytics entities that are looking for data. And really, again, it is a public interest resource, but I do think I think there's a value for people to be able to figure out quickly and cheaply whether or not, you know, they are, for example, is their industry sort of starting to become a target of trolls or other certain types of patent plaintiffs, and this resource allows that, both because we can basically, you know, so we have a search by the code, so that would be like the type of plaintiff, and you can first check all the different boxes, restrict your date range, restrict to particular courts, and then find out how many cases were filed during a certain date range in a certain court, like the Northern District of California, by a certain type of entity. And then we have a party search where we actually, within the database, even though we're mainly focused on categorizing these plaintiffs, we have unique identifiers for every party that's ever been involved, both plaintiffs and defendants in these lawsuits. So you can restrict, and you can look and say, hey, you know, let's look at all the lawsuits against Google, and that can have value both for, since this is sort of a free and open resource, it can have both private value and also public interest value as well.
Cool. Any other questions, folks?
Hi, this is Scott online. Can you please clarify, thanks for your fascinating presentation, Sean, your database's relation to cases from other countries, as well as your plans for international patenting or similar or multi-country patenting. If cases come from other countries to you, how do you navigate maybe those countries' legal systems, or are you primarily US focused?
Primarily US focused, but I would be interested in potentially expanding the scope there. My understanding is, and again, so one of these symposiums, we've had international scholars that came over, and you know, one thing is they like to play with this data because someone from the EU, where they just, believe it or not, it was much more difficult for them to find comprehensive litigation data over multiple EU countries. So I think there's maybe data issues in some of the countries, but you know, at a minimum, another thing about this is it's again really, you know, focusing on who the parties are versus who the patents are. You know, Lex Vecchia does so many things that amazingly. One thing that they've just decided that, you know, they weren't going to do is trying to categorize and sort of focus on the parties themselves. So that's where it fills a gap. If you think of patenting, then, you know, it's also possible already today to download a big report of our cases by patents, and you could match them up with other data sets that, you know, show what the foreign patents are that are associated with these patents that are litigated. So US focus for now.
Thanks very much.
So, John, Lance had another question. He says there are various ongoing efforts regarding the use of AI for patents analysis, such as
Yeah.
the Amuse research and products like PatSeer, sorry. And WIPO seems upbeat on the use of AI. Have you considered using any AI capabilities in your efforts?
I would love to. I have never done it before, so I would need to partner with someone to help me do that. And as far as making this something, I'd be very interested in, seeing if we could train the computer to do a better job than my RAs have done. That would save us a lot of time and money. So absolutely.
Cool. And maybe the last question before we turn it over to Gabe is, in your personal opinion, where is existing law falling short to protect innovators?
To protect innovators. That's a good question. So I would say that patentable subject matter, of course, is an area where more improvement is needed. I sort of think in both the biosciences space and the IT space, the world we had before was before Alice and Mayo and the recent Supreme Court cases. That was not the best world, but then also the standard, the feedback that I'm getting is that it is stifling some innovation, and that there's going to have to be some hopeful middle ground where innovators in both those spaces, but even probably more importantly, the genetic testing, biosciences space, need to have some greater ability to protect their intellectual property going forward.
All right. Cool. Well, Sean, thank you so much for the update. And please put in your contact information in the chat if you could, so people can reach out if they want to follow up.
Thanks so much for the questions, and please contact me if you're interested in the resource. Thank you.
All right. Thank you so much, Sean. It's great to have you. And so let's turn it over to Gabe now with Clearstone IP.
Okay, can you hear me, Roland?
We can hear you well. Hello, sir. How are you?
All right, hello. Good. Great to be back. It's been a number of years since I presented here, so happy to update on our progress. Let's see, and let you know what we're up to. So actually, and it's a pretty good follow-up from Sean's presentation, because where you have NPEs, generally you have targets of those NPEs on the market who make good who have deep pockets and are good targets for NPEs. So they need to make sure that they're not infringing on those other IP rights. So let's see if I can share my screen. Okay. Okay. Do you see my screen?
Yes.
Okay. So thanks again for having me in again. We are Clearstone IP. Our product is a patent clearance and freedom to operate management platform. It's basically a web-based SaaS platform. Again, my name is Gabe Suchman. I'm the CEO, one of the co-founders of the company. So a little bit of background on myself. So I'm a patent attorney. I've been in the industry about 19 years. Started off as a patent examiner at the PTO. Spent some time at law firms doing prosecution, general IP counseling, litigation, basically running the gamut of various IP practices. In terms of what we are going after, to just by way of background, I'll explain a little bit about the current freedom to operate practice as it is in industry. The freedom to operate defined is basically, it's a risk mitigation process that seeks to identify, assess, and mitigate the risk that one's own product infringes someone else's patents. It's also called patent clearance. So those are generally used synonymously. So just making sure that the product you put on your shelves is not going to draw the attention of someone who has IP rights that cover it. That could be NPEs, it could also be competitors or scientists or universities that may have already staked out a claim in that particular technology. The key aspects of doing freedom to operate analysis really involve these kind of four, there's others obviously, but these main four elements is that it involves claim by claim patent analysis, making sure that you're looking at each of the independent claims, at least in a patent, to make sure that those are cleared, that the product is not in the scope of those claims. The process involves key collaboration between the legal department and the R&D departments to make sure that they're on the same page. The engineers need to be informed by the legal department to make sure that the product design is not running afoul of third-party patent rights. And there's always a back and forth there about designing around potential patents, or just basically keeping up to date on the state of the art. It's important to have effective record keeping for this information, because there could be, these patents are obviously alive for the better part of 20 years. So patents that were looked at years ago, decades ago, could even be relevant for products that are on the market now. So we'd never want to reinvent the wheel or do analysis that's been done in the past. And if we can harness that, if we're able to look back at that past analysis effectively, then that's the best way to do this work. That kind of talks about this access to historical analysis as well. And it's important, obviously. This is the main importance of freedom to operate, is that we're avoiding patent infringement. Damages in these cases are routinely in the 8 or 9 figures. With willful infringement, those damages can just triple instantly, just by way of doing something that's intentional or otherwise, kind of deliberately, like copying. The jury is just going to decide that something was intentional, and then the judge can enhance those damages by up to 3 times. So that could just really kill a product line or even a company. Also, just doing FTO routinely accelerates innovation by making R&D and the engineers aware of the state of the art on particular technology. They're better able to advance it, better able to design around potential minefields that competitors may have already staked out. For startups, it's a good way to demonstrate business viability to potential investors. Who's doing it now? So there is certainly a spectrum across industries, a spectrum of intensity among the industries. So most companies that have products are doing some amount of freedom to operate. The exception there is like pure software companies. They're generally not doing a lot of freedom to operate. That partly because of the eligibility situation with Alice and the fallout from that. It's very difficult to really ascertain, do effective patent analysis with software patents. But for the most part, anything with hard goods, electronics, even consumer products, they're doing freedom to operate to a large extent. Very high on the spectrum are medical and healthcare fields. So we've got medical devices, medical goods, pharmaceuticals, biotech, very, very intense freedom to operate work being done there. And then of course, consumer products, electronics, appliances, and sporting goods, anywhere where there's like a product that's on the market, and particularly where there's high profit margins in that product, is where there's a lot of freedom to operate being done. Whether it's done by in-house counsel or outside counsel, they're both doing it to some extent. The in-house corporate market, from our perspective, is a larger market, and it's more accessible, and they're more ready to buy. they do own this process. So typically when it's outside counsels doing the work, they're getting maybe some of the more critical work coming from in-house, but the in-house group is doing the large bulk of the work and they own that process. So they'll see like the routine process, whereas they might send some work outside for larger projects. For in-house legal counsel, we're seeing that patent counsel is spending between 40 to 90% of their time on freedom to operate. So that's pretty substantial. And frankly, I was surprised to hear that when I first started this business, because we see a lot of attention directed towards patent prosecution, the procurement of patents, and not so much attention on the freedom to operate side. So to learn that they're spending usually half or more of their time on freedom to operate, it really represented the fact that there is a huge market for this particular practice. The general process for freedom to operate is generally 3 phases. The first one is searching, so doing a patent search, getting the relevant patents. And then phase 2 is analyzing those patents, and phase 3 is mitigating the risk. We, Clearstone FTO, that's our product. We're not really a search tool, where there's plenty of really good services out there. So we're not really directed towards that. We're not trying to reinvent anything. I noticed Stephanie Curcio on this call. She's doing great work as well with Legalicity. I recommend them. But in any event, we're on the second and third phases, basically analysis and mitigation. That's where we come in. What the conventional systems that are being used in that for those phases are like Excel, Word, Lotus Notes, Access, and SharePoint. Basically, everybody's using Excel to capture this work product, and we're seeing just a lot of shortfalls with that process, and that's where we come in to make the process better. With Excel, it's really time consuming to perform basic functions. They lack integration with relevant information, difficult to aggregate and access historical analysis, and collaboration is difficult. So basically it's just, it's old and not utilizing what is available now. So here's where we come in.
Are you planning to show a demo or do a demo?
I can demo. I have some screenshots, but
Okay, sure. Go ahead. Sorry, I didn't want to interrupt. So I want to make sure
happy
we
to
leave
demo.
some time for questions also, if you can.
Sure. Where are we at? Okay. Yeah, I'll get to that quickly. So just generally speaking, we are the only commercial platform that's purpose-built for managing patent clearance. We're sort of the first in this space, so there is a huge opportunity for growth, and we intend to define the industry standard for this, for FTO management. It's been validated. We currently have 6 figures in ARR with basically the founding team running all of the sales and marketing. We have some marquee customers, including Roche, ResMed, Nuvasive, and Cabot Microelectronics. And we're pretty close to closing deals with several Fortune 500 companies within the near term. I'll get through these very quickly. Essentially, we're making the whole process much more efficient, and while adding value to, while basically building up institutional knowledge so that access to historical work product is instantly accessible. So I have some screenshots here and I can kind of just explain them. And in the Q&A, if anybody would like me to sort of go live, I'm happy to do that. Essentially, the way it works is that we create the software packages the information into what we call FTO review packages that correlates the specific product that's under investigation with sets of patents that have come up from a search. And here's sort of a dashboard on that review. It's all collaborative, it's all in one place, so it provides real-time project status. There's advanced sharing capabilities so that lawyers can collaborate very closely and transparently with the R&D department or outside counsel. This is what we're looking at here is the patent review interface. So this is the the deepest level of analysis that we need to do here. We're going claim by claim on the actual patents and making claim by claim determinations, because there could be different things happening for each claim. So we can clear one claim but have a problem with another one. So being able to go claim by claim is very important for this process. So there's a whole multitude of ways to capture work product, highlight claim terms, tag, attach documents, whether it's opinion of counsel and invalidity charts or things like that. It's all in a central environment. And the last screenshot I have here is what we call the patent review history. And this is a key feature. This is really the crux that drove the whole motivation to create a centralized location. And that's dealing with a problem of seeing patents come up that have been looked at before in the past, and that could have happened months ago or years ago or decades ago. And it's really frustrating when you can't find that historical work product. So by putting everything in a central system, we're able to tie that all together. So if a patent comes up and it's been looked at before, whether that's by somebody else in the company or outside counsel or an engineer or anybody, there's a button that lights up and it says, this patent has history, and you click that button and it instantly tells you all of the reviews that have contained this patent, along with the work product and analysis and documents, attachments that went along with that analysis. So this is sort of compounding the efficiency, saving a huge amount of time, saving having to reinvent the wheel every time we need to analyze the same patent. So that's sort of the main functions. Just a little bit of more background on our company, our team. So two of the co-founders are patent attorneys. We've got a number of years in the industry and seen it from various directions. Our third co-founder is our head developer, really smart guy who makes everything happen. Here's just a group of our current subscribers. So this is sort of demonstrates the range of industries that we serve. We've got software, pharmaceuticals, sports equipment, and size of companies. We've got companies that are startups, mid-size, small, up to some Fortune 500 companies as well, really large companies that have a lot of products on the market. So it really kind of shows our breadth. So that's all. I'm happy to go into a live demo if anybody would like to see that or answer any other questions. And yeah.
Thank you, Gabe. Yeah, very cool. Yeah, since you presented the first time at CodeX, this is several years ago, you've like really gotten a lot of traction in the market, and it's very exciting. Do you see any competitors who are trying to do this? Because there's a lot out there in the IP and patent search space, but this FTO space, I'm not aware of anyone else trying to do that.
Yeah, that's we believe that we are the first in that area, and I don't know of any other commercial offering. It's there. You know, I think we started the company a number of years ago with a different product, and that's actually what I presented at CodeX the last time. We've shifted to more of a workflow management tool because there wasn't anything out there, and we felt like the feedback that we were getting from our customers was that they really needed just a foundational management platform, not so much the sort of specialized niche tool that we were building at first, but really just the foundation for the work and a place to put everything. So that's why we shifted towards this more broad-based management platform, and it's been really well received. So I think we just kind of got out ahead and are lucky to have done so.
And you're charging your customers by the seat as a subscription by the seat, or how does it work?
Yeah, so our pricing is generally by the user per year. So it's $3,000 per user per year. At larger companies where there's more than about 8 or 9 users, it makes sense to move into like an unlimited user package, and that's tiered based on like the number of reviews that they do on a yearly basis. So that's, yes, it's essentially like that.
And what's your long-term vision for your company? Are there sort of adjacent areas that you can go into, or you just want to capture more market share?
Yeah, there's, because we're sort of, I believe, pioneering this sort of space, there's a huge amount of white space just in this vertical. But that we certainly have a vision within it, and to expand beyond this narrow vertical. So I've got this point here at the bottom. We're laying the foundation with basic workflow tools. And then in the future, in our near future, actually, we have in our roadmap to add value to that platform with layering in more analytics, insights, artificial intelligence that will help guide decision-making, and also bring in some risk factors that could help with that as well.
Great. Okay. And one thing I didn't quite understand in your presentation before, did you say that if companies don't do FTO, then they can be hit with 9 times damages, or could it be willful if you do an FTO and you still infringe,
Mm-hmm.
then it's still a willful infringement?
If you do FTO, well, to avoid willful infringement, well, I don't want to get too far into like the law, but like basically if you don't know about a patent, you can't be held to willful infringement. So I'm not trying to say that everybody needs to do it no matter what, but if you have reason to know a patent, like that's sort of the standard. If you knew or should have known about a particular patent and did not investigate it, then willful infringement could be on the table. But if you do freedom to operate and come up with good faith opinions that demonstrate non-infringement or invalidity of that patent, that's pretty much the best prophylactic against allegations of willful infringement.
I see. Cool. Okay. All right. Does anybody else have a question? All right, it's pretty quiet. We're a little bit over our time already. Well, in that case, let's wrap it up here. If you could perhaps, put your email into the chat, that would be great. So if anyone has a follow-up question, they can reach out to you directly. But thank you so much. I'm really excited. Yeah, Scott's wondering in what ways all the 3 presenters could work together. He wonders. So yeah, I don't know. That's a good question. So well, thank you so much to you, Gabe. This is really cool. Yeah, having built such a successful company, and good luck for your next steps with that company. And please keep us in the loop. And thank you to
Thanks very much.
To Sonia and Sean, and to everyone who joined us today. And yeah, please all stay healthy and safe. We'll see you again very soon, hopefully.
Yeah, next Thursday we have our last meeting of the quarter.
Next Thursday, last meeting of the quarter. Okay, so stay tuned for that, and see you all next Thursday then. Thank you again. Thanks again, Gabe.
Bye, everyone.
Thank you, Roland. Appreciate it. Thanks, Susan.
Take care, everyone.